This is Barry Zalma speaking for Zalma's Insurance Fraud Letter, issue number 4, volume 26 for February 15, 2022. This issue usually appears on my blog, but for some reason I have been unable to connect with my blog, and the technicians are working on it. So we'll see when it comes free. If not, you can read the PDF in a few days, or you can just subscribe to the fraud letter on the link at www.zalma.com, and it will provide you with a complete copy. There's also a posting of my file on locals.com and at substack.com. This issue starts with a story called Go Directly to Jail, Do Not Pass Go, where a person convicted of insurance fraud showed amazing chutzpah, that's unmitigated gall, by appealing a conviction to avoid going to jail. Tarek Abou-Khatwa appealed his conviction of a complex, multi-year insurance fraud scheme. He previously had asked the court to delay the start of his incarceration pending the outcome of an appeal. On January 31, 2022, the court declined his request, explaining that defendant's appeal did not present a close question as to each count on which he was sentenced to prison. In the United States of America versus Tarek Abou-Khatwa, the United States District Court dealt with Tarek's multiple appeals in an attempt to avoid, again, his imprisonment. He filed an emergency motion with the United States District Court, stating his intent to lodge a second appeal. That again failed. First, 18 U.S.C. Section 3145C pertains to appeals of detention orders, not release from custody, and so it was inapplicable. Second, nothing in the court's January 31, 2022 order restricts the defendant's ability to seek relief from the Court of Appeals. The court, aware that the timeline for defendant to both appeal this court's January 31 orders and receive a decision on the appeal before his February 10 self-surrender date, is truncated. However, defendant, not the court, bears responsibility for the accelerated schedule, and since that date has passed, one can only hope that he self-surrendered and is now spending his time in prison. There's another article called Fraud by Insurance Company Officials, where we discuss how some insurance company officials get involved in insurance fraud, defrauding their customers rather than the other way around. Overlaying a broker-centered conspiracy, the plaintiffs averred that there was a global conspiracy, and in this alleged scheme, the defendant brokers, with the complicity of the defendant insurers, agreed to conceal from the general public and other brokers, that is, non-conspiring brokers, the existence of the broker-centered conspiracies and the details of the contingent commission agreements. The plaintiffs contended in their action against this conspiracy that informational output that directly affected the price of insurance, and the district court concluded that the complaint's factual allegations failed to plausibly imply horizontal non-disclosure agreements among the defendant brokers or the defendant insurers. Rather, the court found that it was clear that at least the following activities are the business of insurance, either because they pertain to risk spreading or to the contract between the insurer and the insured. 1. Preparing and filing rating schedules, either on behalf of an individual company or jointly through rating bureaus. 2. Deciding upon rating classification differences between individual policies and group marketing plans. 3. Authorizing agents to solicit individual or group policies. And 4. Accepting or rejecting coverages tendered by brokers. Because the McCarran-Ferguson Act does not bar plaintiffs' claims, the court's analysis is dispositive given the long path our discussion has taken. A brief synopsis of that analysis is in order. Courts confronted with a motion to dismiss must assess whether the complaint contains enough factual matter taken as true to suggest the agreement was made. Because they plausibly suggest an unlawful horizontal conspiracy not to compete for incumbent business, plaintiffs have adequately met the requirement for setting forth a claim against these defendants in the asserted commercial conspiracy, who are alleged to have participated in bid rigging. The agreement to divide the market, if proven, would be a naked restraint of trade subject to per se condemnation. The Third Circuit concluded, quote, "For the foregoing reasons, we will vacate the dismissal of the Sherman Act claims with respect to defendants alleged to have engaged in bid rigging on the Marsh-centered commercial conspiracy, the dismissal of the RICO claims on the alleged Marsh-centered commercial enterprise, and with respect to the same defendants, the dismissal of the RICO claims based on the alleged CIAB enterprise with respect to the defendant brokers, and the dismissal of the state law claims. We will affirm the district court's judgment in all other respects and remand for further proceedings." In addition, the fraud letter includes an article from the California Department of Insurance, who issued 14 cease and desist orders to protect California consumers from unlicensed health care coverages provided by entities such as First Continental, Administrative Concepts, Association for Better Health, Association Healthcare Management, DBA Family Care, Evolve Health, First Health Network, Get Me Care, National Association of Preferred Providers, Service Industry Trade Alliance, Matthew Dupre, Curtis Garcio, Fabian Vergara, Samantha Maybe, and Scott Russell. If you obtained insurance from any of these entities, contact the Department of Insurance because they were not licensed to do so. Then we published good news from the Coalition Against Insurance Fraud about convictions reported by that entity. An article called "The Examination Under Oath" that is a detailed rendering of the law around the use of the examination under oath, and which was adapted from volume 2 of my book Insurance Fraud, which along with volume 1 are published as both Kindle books and paperbacks. Then we list health insurance fraud convictions, including a psychiatrist who was sentenced to only 120 days for falsifying disability reports, a Milwaukee pharmacy chain that was required to pay $2 million to resolve False Claims Act assertions, a Key Town situation where Cardinal Health was required to pay million to the government to resolve kickback allegations, and many, many more convictions and orders. In addition, we publish other insurance fraud conviction reports, starting with an Oceanside man who was convicted of defrauding his ill brother out of $120,000. Jennifer Faith, who pleaded guilty to murder for hire in her husband's death. An unlicensed agent who got 4 years in prison for a $1.4 million insurance fraud, and many others. There's an article on excellence in claims handling and how any insurance entity can provide excellence in claims handling. And the last 10 postings to my blog, Zalma on Insurance, all of which are available at zalma.com/blog, although the new postings will not be available for a few days. You can subscribe to the newsletter by simply clicking on the appropriate link set forth in my website at www.zalma.com. Thank you for your attention.